So welcome everybody. We're on time. We have about 30 people in the chat. So I'm Sarasvati. I'm here in Boston. As most of you, if you're coming from WhatsApp group, you know me well. We've been running that group for about a year now, since last year. So I also run H1B the Substack community, helping fellow founders and aspiring entrepreneurs who are here on H-1B visa or F-1 visa, OPT, stuff on EB-2, like I was for 15 years. And so with me today, we are joined by Raghavan Nagarajan. Raghavan is a partner at Sarasvati Law, and he was my attorney when I was desperately trying to figure out, the key question: can I start a company on an H-1B, and can I be a founder? Raghavan was, I consulted with him early on, and then I got a lot of confidence speaking with him, like what's possible, what's not possible, the idea of passive investor and how I could still nurture my company in a way without jeopardizing my current H-1B. And then eventually we filed my H-1B through my own company, Trial and Error Inc. That got approved, which we also rescinded like 2 months ago because I got my EB-1 and the green card. So that was my story. I've shared this in other podcasts and few video calls. I'm not going to go in details about my story in this. Here, we wanted to focus on the recent H-1B changes in the USCIS directives that have come out. So we'll focus on discussion there. But just like last call, people have all sorts of questions at different angles and different thoughts because, many people have at different stages of their entrepreneurship journey. So feel free to write down your questions thoughtfully, and the more specific you can be. I figured last time, I think Raghavan can really drill down and give you a better guidance there. Other than that, I think that's it. I think I'm going to give the mic back to Raghavan, to you, maybe.
Yeah. So as Sid said, my name is Raghavan. I'm a partner at Sarasvati Law. I guess what we want to do is talk here mostly about this updated H-1B rule. I was just chatting with Sid before the call. I imagine that in fact, a lot of people are likely going to have questions about other things, one perhaps important one being how much will the new administration continue to adjudicate cases along the same policy guidelines that the prior administration did. Problem for some of those questions is it's a real big unknown, what will happen in the future. So what we could talk about, I guess, now is what are the rules now? Maybe what was the evolution to get the rules here so we can have some idea about what might come up in the future. But some things I'm not going to be able to really talk about or understand or explain because we just don't know what tomorrow is going to hold. But in terms of these updated H-1B rules, it's actually today's the 23rd, right? So January 17th, last Friday, less than a week ago, is when these new rules came into effect. And these new rules basically address a couple of different aspects of the H-1B. Probably most pertinent to you guys is the aspects of it that address H-1B founder. But there are other aspects of these new rules. They've enhanced some of the enforcement capacity and the site visits, the auditing of whether people are actually following the details that they indicated on the LCA, on the H-1B petition. So there's some details related to that. Also, there's some information and an update about how they're defining what it is to be a specialty occupation, really making a radical change, but making these small evolutionary changes that perhaps reflect, the government always says, this just reflects what we've always been doing. But, that's kind of language that government always says, even if they're making a change. So probably this is a little bit of a change in the specialty occupation analysis that might make it a little bit easier. I can talk about what that means if those questions come up. But also there's some updates and edits to how they define what institutions count as being cap exempt and whether you can do employment at a cap exempt institution and therefore avoid going through the H-1B lottery and what that kind of looks like. So there's a couple of those updates as well. The big, for us, I suppose, ticket item is this update in how the government is saying it's going to analyze an H-1B petition when one of the people who owns the company is the H-1B founder or the H-1B beneficiary themselves, right? So I think most of you people are in this position where you're exploring this, you're interacting with this community, you've got these questions because you're looking to work on your own idea, work for your own startup, perhaps work for a family business or one that you're just about to start, work as a consultant, maybe develop some new idea, but ideally just do work for a company that you have some ownership in. Historically, what we would say to you is the same thing that I said to Sid and we've said to other people in the past, and that is you've got three things to worry about if you want to do a transfer to a company that you own. The first thing, and perhaps the most important thing, is you need to be able to demonstrate that there's a difference between the company as an entity and, an employer and you as an individual and an employee, right? This whole employer-employee relationship and whether the employer controls the employee relationship was the first key element in being able to show that you could actually file this H-1B petition. Second element was, is there work for you to actually do there? Does this company now really exist? Can they actually give you work? And then, are you going to get paid an appropriate amount? How long is that going to last? Those kind of things. Well, now this updated rule, they've made it explicitly clear. We are removing all of the requirements that we had before for the company to show right to control. You don't need to show that a company has a right to control the employee's employment. Not a question they're going to ask, not a question that you need to address. You do, as all filings that are for these employment-based categories that you use this form, all of those filings in some form ask you, hey, is the beneficiary an owner and having an ownership interest in the business? You still have to answer these questions. Do you have an ownership interest in the business? But your answer to that question isn't one that means somehow you now cannot qualify or you have some difficult burden to overcome. Instead, if you indicate, hey, I control a majority of the business, I own a majority of a business, I'm a 50% owner, 70% owner, 100% owner of this business, then you, if you're filing an H-1B, just have to follow these extra, what the government is calling guardrails to be able to get your H-1B approved, right? If you were filing an H-1B through Google, then Google files the petition. You guys probably all know this already or have experienced it in some way, but I'm going to just take a few minutes to explain just so we're all on the same page. That process of filing an H-1B petition is company first says to the Department of Labor, company first says to all of its current employees, hey, we're planning on filing with the Department of Labor for a position in this location in this occupation, right? It's called this notice of filing. Then they submit to the Department of Labor, here's the job title, the job category, because the government has a system of specific occupations, and the salary we're going to pay, and the locations the person is going to work. They have to fill all this data out in this application to the Department of Labor, and the Department of Labor will look in their system and say, okay, based on what you are reporting to us, do we think that you're paying at least what a U.S. worker in that location, so the job you described, is going to earn? And that's a relatively simple step because there's publicly available Department of Labor data on what these prevailing wages are. So you just look them up, make sure you indicated the right amount, put that in. The Department of Labor takes a week. Company gets that certified. Then the company files and says, I have this job. Here's the job description. Here's how this person is going to do this work at my company. I want to offer it to this person. Here's their qualifications to show that they have the appropriate qualifications for the role we're offering. And I'm actually going to pay them the amount that I noted in the LCA. And the way they'd adjudicate is, all right, let me look. Do I believe you're a real company? Did you meet the LCA requirement? Is this person qualify? Now, if you're a founder, if you Google, you go through the step. Now, if you're a founder, your own company has to still go file the Department of Labor step, get the LCA certified. So you have to exist as a company, submit those details, say you're going to pay the appropriate amount. And then when you file the H-1B petition, you indicate, okay, the beneficiary has 100% ownership interest in this company. And then what the government's going to do when they see that happening is they're going to say, all right, let me read this job description and make sure that the job duties, a majority of the time, are describing that a majority of the time, the person is going to actually perform the duties of this occupation. So you say they're going to be a software engineer, are 50 plus 1% of the job duties focused on software engineering? Yes. Okay, right. They're really going to be a software engineer. 2, do I have enough evidence in the record to see that there can be a software engineer at this company, right? Maybe it's a new company just formed yesterday. How do I know they're going to have work? They've really honed in on this requirement, kind of redefined what they mean by it, and have indicated there has to be a bona fide job offer, right? When they did the draft of this, the way this process works to update these policies is they publish a proposed rule and they put it out there and say to anybody who's interested, you have 90 days to comment on it. And we'll take your comments and we'll take probably months, go through them, update them, and then we'll publish the final rule. So what we have now is the final rule. In the proposed rule, they've suggested you need to have non-speculative work. In the final rule, they've gotten comments from people saying, what does non-speculative mean? That's too vague. How do we define that? What does it mean? So they said, all right, okay. We're going to say you have to have a bona fide job offer. You've got to legitimately show there's a real job there. We're not going to call it non-speculative because we think that's a little risky and maybe people can get confused and hard to prove what is speculative, what isn't. Instead, show us there's a real job. I don't know how that makes things easier, just a slight change in definition. But in practice, I would say company could show you have a bona fide job if there's work for a person to do. Yes, and one way to show that would be, look, here's contracts this company has for this person to perform on. But not all companies are built that way, right? You might be forming your company because you're going to do market research on developing your product that you're creating, right? And that doesn't mean you have external contracts. And they're not saying you have to show me external contracts. They're saying you have to show me a bona fide job offer. So if you can demonstrate perhaps a business plan, product plan, a project plan, sometimes in the past, in the long past, we would respond to these things and provide a Gantt chart, right? Here's in these months, what we're going to do on these projects and how we're going to accomplish them. Maybe these are the kinds of evidence that you would show to convince the officer. But the point is you got to show a bona fide job offer for a person to do a software engineering job. More than 50% of their time is software engineering. They've got a degree that's closely related to it. That's directly related to it. Sorry, closely related is perhaps old language now. When they've updated this definition of specialty occupation, they've made it clear there has to be a direct relation between the degree or the degrees that you list and the job. And so if you show those things, you can get the H-1B approved for 18 months, right? Not for the full 3 years, but for 18 months. So what that means as a founder is you no longer have to be concerned about the fact that you're moving to a company you own. You have to be concerned about the fact that you're moving to somewhere where you're really going to do this work, right? If it's a company you own, fine. You still have to prove there's work for you to do. This company you don't own, you've got to prove there's work for you to do. So if you were employee number 1 in a startup that formed yesterday, or maybe employee number 2, I guess, if the founder is employee number 1, then you have the same burden as if you are the 100% owner. So that's the kind of high level dynamics that they want to introduce, that they have introduced, right? Of course, there's that open question of what will we see in the future in terms of the Trump administration's reaction or update to the rule. A cynical person, I think, and perhaps I'm one of them, would say that the timing of this by the Biden administration was directly related to the fact that 3 days later, a new administration is coming into office. So perhaps giving the most possible time for people to use this rule, right? Because this updated rule, when we say that, what we mean is they updated the actual code of federal regulations, right? Like updating the law is difficult because you update the law, you need Congress to make a change. But the agencies can update the code of regulations. That's what's been edited here, right? It says in writing these rules. And so for the new administration to update that would require them to do the same process this administration or prior administration did. Publish a proposed rule, give a notice and comment period, review the comments, then publish a final rule, right? That takes time. And so at least for the foreseeable future, I imagine this is going to be the regulations. The question is, how will they enforce the interpretation of these? And I'm sure there's going to be questions there. I've seen some of the thread. I don't necessarily in this forum have a good visibility, and I get all the questions that come up, but I'm sure Sid you do. So maybe you can ask some questions.
So people, if you want to type something, please do. A few questions on top of my head so that's great explanation. Even I think a few things clicked in my head as you were explaining this. So, Raghavan, it sounds like some things are more clear and strict now, like specialty occupation, they've made it stricter and more defined. But also,
sorry to interrupt. I think they have more clearly defined what they mean, but I don't think that definition is more strict. I think the definition of specialty occupation is less strict than it used to be. One, I think I didn't explicitly say this, but previously you'd seen officers issue requests for evidence about an occupation and argue, well, you haven't demonstrated that you'd always need a bachelor's degree in a specific field to perform this position. And the words used in the rule said normally requires, but they would interpret that normally to mean, basically always. Now, one of the things they've clarified is normally does not mean always. And that's in the kind of language now. So that's a little bit looser. And also they've clarified that there could be different fields. You could legitimately today say, hey, this job requires either a bachelor's degree in software engineering or finance, right? If you had said that to the prior standard of rules, you would almost definitely get an RFE saying, wait, software engineering and finance, so those are radically different fields. How are these fields related to each other? And how are they related to the position? Adjudication standards kind of shifted. You guys, I'm sure, have filed cases, experienced cases on an individual basis for yourself. But if you file lots of these cases, you see these trends. Adjudication standards have shifted over time where they're less to push back on that today than they were 3 or 4 years ago. And now they've kind of encoded that to say, yeah, even if you list 2 different fields, we don't care that those fields are different from each other, as long as you can show they're both logically related to the position. So if you're saying, I require for this position a bachelor's degree in software engineering or a bachelor's degree in finance, that's fine. We'll accept that. If you can show how software engineering is related to it and finance is related to it, and they're both bachelor's degrees, so that would work. So sorry to interrupt.
Gotcha.
I don't think that that's got stricter, but their kind of definition of it has tightened up.
I think I saw a couple of things of revenue, but before, this one's interesting. Well, what are the components of a bona fide job offer?
So the first thing to say is that it is not the case that they have some list that they've defined to tell us that. But in my experience, I would say if you have the fact that the company really exists, so company is incorporated as a federal employer ID number, these things have to be true in order for you to even file the LCA. So those definitely are true. But then you have some explanation of what the company is doing with some evidence to support it. For the sake of argument, let's say, formed the company last month. Here's my business plan. I'm developing an app to better market seltzers, right? Great. We're developing AI to target to people what's their favorite flavor of seltzer and how they're going to buy it more conveniently at a local store or something. And so I've got this plan, I've done some analysis of the market and said, oh, look, there's a gap in the market. People want to drink these seltzer waters because they want to get off soda, but they just don't access them as easily. They always see them in only a Wegmans or a major supermarket. You go to a drugstore or a gas station, you don't see them. So we got to have some mapping, and this is a big market, and here's the need, and here's my plan. We're going to develop this app over time. I mean, these things that I'm describing are basically the thing an entrepreneur would do, right? And this is what you do when you figure out your business, right? So let's say you've done all those things and you have some plan. Maybe it's a pitch deck that you're using for investors or something like that. I would say if you've got company formation details and you've got a pitch deck and you've got that detail of what this, if you're hiring somebody as a software engineer, I use that as an example because it's a simple example and because many people end up fitting that profile, but I don't mean to suggest it's the only profile that you can do an H-1B for. But yeah, I mean, you've got some plan and software engineer can do this work. I think then you can say, hey, I've got a bona fide job offer because I've got a thing this person's going to work on. They're going to work on designing and developing this app and building this feature set. And I don't know, maybe you're further along. And so they're going to work on customer integration of these things because we have a minimal viable product. But you've got something that they're really going to do for work and you can pay them, right? Because you still have the minimum prevailing wage requirement. And so you got a job offer to pay them to do this work. And that's a bona fide job offer.
Okay. So on on the payment part, I think somebody asked, what is the minimum revenue or the bank balance? We get this question all the time.
Yeah.
What would you say on
This
that?
question before as well. And by that, I mean before the update in the rule change. And I also mean before in our previous conversation. And there's no like strict answer to that, right? I can only speak for the subset of these cases that I've filed. Obviously, the government's going to have seen thousands more in the cases that I would file or my firm would file. Now, we filed cases, for example, where a company has $30,000, $40,000 in the bank, right? But they've got a plan for something they're going to do. Maybe they've got a plan that also includes a financial plan, like here's how we're going to potentially generate revenue. Here's how we're going to gain investment, something, I don't know. And that's enough, right? The law doesn't require explicitly, and the way that these officers have adjudicated has not required implicitly that you have a bunch of money in the bank, right? You could have money in the bank. It is not necessary to have money in the bank. Sometimes it's sufficient because if you showed, look, I got $250,000 in the bank, and good evidence that you've got a real job to do, right? If you had $2 million in investment, an officer might look at that and say, I'm convinced, right? I don't need to be convinced by your fancy plan. Somebody gave you $2 million, you probably going to do work, right? And so having money is a good thing because it's persuasive, but it's not required. You could, in theory, you could file with no money in the bank. I've never filed a case with no money in the bank. I've always said, hey, put some money, with at least, I like to advise people, put 6 months to a year's worth of salary in the bank. Have that there, so at least you could show that. One thing that I believe, and a lot of what we're going to talk about are things that I believe, because unfortunately, it's not like I could say in the 6 days that this rule has been in effect, here's all the cases we filed, the adjudications we've seen, right? There's probably nobody that's seen any adjudication on this new system yet. What I would advise is have that, 6 months to a year worth of salary in the bank. And I think because they're limiting the H-1B founders to 18 months of an approval, maybe it's a good idea to say, look, let me show how I'm going to be able to get paid for 18 months. Right? It's a shorter period than the 3 years, but you could build it. You could de-risk as much as possible by saying, here's an 18-month plan, right? And imagine filing a petition where you have an 18-month Gantt chart and you have a project plan and you've got money to fund those 18 months. It'd be really difficult for an officer to deny that and say you don't have a bona fide job offer. You've shown that you're going to do work for the entire time they could approve it.
So this is actually the newest part of this 18-month approval of H-1B. Shall we talk more about that a little bit? So
yeah, I mean, it's pretty simple, right? So the longest any individual petition can usually be approved for in one of these kind of employment-based categories is 3 years, right? That's kind of the standard. H-1B has an overall maximum of 6 years. Of course, there's exceptions to that. If you filed a certain part of the green card process and a green card's not available to you, then you're exempt from that 6-year maximum. I think many people perhaps in this community might be in that position, but the most you can get in one filing was 3 years. That doesn't mean you're required, and it's never meant you're required to ask for 3 years. People just always did, right? It's like, well, I might as well ask for 3 years. I can ask for 3 years. I will, but you're not required to. Well, now they're saying if you are a majority owner, right? If you're one of these people that kind of fits within the H-1B founder, as we're describing it, category, then the most we'll approve the petition for is not 3 years. The most we'll approve it for is 18 months. Doesn't mean they won't approve it for less. You could request 6 months, but probably 18 months is a short enough time period, I think, that you could have good evidence that you've got a bona fide job offer, you got work to do for 18 months. But that's what this is. 18 months.
Is this 18-month extension after that too?
So yes to that question, but then no to the next one, right? So 18 months for the first filing, 18 months for the second filing is what they've said. So after the second filing, you could potentially get it for 3 years. So let's say you own 100% of a business, you file an H-1B, you get 18 months, you extend, get 18 more. When you extend the second time, even though you still 100% own it, they'll approve it for 3 years. This is what they're saying today.
Still have those
right?
6 years. You still have those 6 years.
Yeah. Nothing impacts the 6-year maximum. Nothing impacts the per country limitation or the lengthy adjudication delay exception, those things. So those still aren't impacted. it'll be 3 years until we see whether they're actually approving things for 3 years in those second extensions, right? But that's what they're saying they could do.
Somebody asked, even if, I don't know if you can read that as well, Raghavan. So even if it would be a transfer, would it be 18 months? I think they mean that if I transfer my H-1B from somewhere, would that still be 18 months?
Exactly. And it still would be 18 months. We're not talking about, and nothing about this rule is limiting it to H-1B cap cases. When they say the first filing, they don't mean the first time you've ever held H-1B status. They mean the first filing as an H-1B founder, as the majority owner of the company, right?
Yeah, makes sense. Now, this question we get often about concurrent H-1B. So the second part is the most interesting, which is, can we start with a concurrent H-1B for 15, 20 hours per week as co-founder? So while I think what they mean here is I have a job as well. I'm being compliant on H-1B.
Yeah, definitely.
So the answer is
you
yes.
always could, and you still can. There is nothing in the immigration rules or law that has prevented anybody from having concurrent H-1Bs for the last 15 years, right? I guess I couldn't speak further back than that. I could talk to Michael Sarasvati, he'd probably say for the last 25 years, right? You could do that. The only reason that I see people don't do that is things that have nothing to do with immigration, right? I can't do the concurrent work because I'm working at this big tech company and I signed an employment agreement there and it says I'm dedicating all my time to the big tech company and I've got an IP assignment. And if I start doing part-time work, I'm worried that my IP for my own company gets muddied and maybe it's owned by this company I work for. I don't want to have any of that. And so
conflict of interest.
Clean, exactly.
Right.
Those are all non-immigration questions.
Moonlighting clauses. Some companies don't allow you to do moonlighting. So this is actually pretty good. I just want to, stress that because we get this question many, many times in the community. Sounds like concurrent H-1B has been possible before. It is possible now. Nothing changes. Now, I do think some people would ask the follow-up question, which is, okay, so if I want to start my company and be a founder as a concurrent 15, 20 hours, so then my salary requirements is lower because I'm working less. Does that benefit me in somehow? So now could I show less money? Does that help?
100%. Definitely benefits you, right? It benefits you in a lot of ways because you don't have, probably the biggest problem that you have as a founder. I guess there's a second category of problems that we deal with because you're an immigrant founder. But the biggest problem that one has as a founder is how do I get money to do the thing I want to do right now? Unfortunately, the H-1B has the LCA requirement that you have to be paid the appropriate prevailing wage for that occupation. And nothing about this new rule gets rid of that. And they tried, right? When I say they, commenters tried. In the proposed rule, they put it out. People responded saying, but it's really tough for startups. Could you maybe have some more flexibility on what the salaries would be? And the government's response was, number one, no, we wouldn't do that. But number two, even if we wanted to do that, we couldn't do that because that's really governed by the Department of Labor and not by us. And so we can't make those changes here at USCIS. A little bit of a cop-out, I bet they could have if they really wanted to. But basically, they've explicitly said, we're not changing anything to do with that, right? When you file an H-1B petition, you got to say you're getting paid a certain amount. You got to actually get paid that amount. The only way that we have historically found consistently to be able to get paid less is work less. So do part-time work. So if you're going to work 15 hours a week for the startup, then you have to get paid 15 hours a week, right? If it's a prevailing wage of, let's say, $100,000 a year, most likely that's going to translate to something like $50 an hour, right? And so instead, if you're working 20 hours a week, $50 an hour, 20 hours a week works out to $50,000 a year instead of $100,000 a year. So that's your savings, right? Of course, what's implicit in that discussion is you're working 15 hours a week. I guess we all kind of have an idea that you're founder of a company and how am I limiting my time to this? I want to dedicate more time. What I would say is legally, you should be working the amount of hours per week broadly that you have reported, right? And so if we're saying I'm going to work 15 hours a week, you work, somewhere between 5 to 25 hours a week, fluctuating, fine. But keep track of your time, right? Keep track of the official time. This is not what the rules say or the law says or the government says. This is what I say, right? What Sarasvati law says, what we say is keep track of your time contemporaneously. right? Use a time tracking app. They're out there. They're out there and they're really good because there's a bunch of them that also have location tracking for your time, right? Perfect, right? Track your time when you're at the appropriate worksite location, doing your work contemporaneously, report every 2 weeks. Look, here's my 15 hours in my timesheets. I'm reporting it to the company. The company's paying me. I'm getting my actual payroll, indicating that appropriate thing. It's paid because in a year and a half or 3 years or whenever, if the government comes back and asks you, you can respond with it. I'm not just telling you I did it. Here's records from the time. There's no better evidence in a court or in one of these things than contemporaneous records that were kept because it was the company's standard business practice to keep, right? Those are really persuasive. So look, how can you tell me that I worked full time? I got contemporaneous records that I worked 15 hours a week from this tab that I paid at that time. Great evidence. So do that when you're doing part-time work.
And I would suggest, on the same line, like when you operate your business in this, do operate it like a business. And we talked about not mixing your personal funds with, business. Most people should have a business account, even if you do an LLC, operating like that. So keep those things different. And just like how you say in taxes, if you're going to expense something, have the receipts, right? So you gotta follow that process, and it's not that hard. Like with the Gusto and other HR system, you could have, 2-week. If you're paying yourself, you could record your time and make it a habit so that it doesn't look, don't get casual on these things. I think there's a tendency that we become very casual because it's a 1-2 person company and we're like, oh, we're just running it, figuring things out. So I think
there's a couple questions just here
way.
that I'm seeing. I'm sure there are further questions further up the chat, but that are just related to what I was saying. So I just want to address a couple of those.
Sure.
Does the USCIS ask if the other company's aware that I'm going to work in my own company? No, there is no direct information that I'm aware of that a company you're working for would receive. Suppose if your work site location is one that mail goes to, that company's aware of mail being delivered to, maybe it's an angle, I don't know. But let's say you're working for a company and you decide to do this, whether it's your own company or some other, you just found another job. When they file their LCA, they're indicating current employment, but it's not like the Department of Labor sends info to the old company. They just adjudicate it on the basis of what you submitted. When the government approves it, they just approve it on the basis of what you submitted. Nobody tells your old company. And so you may want to tell your old company, fair enough, but if you don't, then the government's not going to. The second thing is, what if you start concurrent part-time and you want to go full-time? Yes, you can do it for sure. Unfortunately, there is a cost, right? Because when you make a change to the details that you submitted on an H-1B, if that change is what the government considers material, then it requires a new petition, a whole new file, right? And the change from part-time to full-time is a material change. So if you're doing part-time and you indicated on your petition, hey, I'm going to work 5 hours a week, and you end up over time increasing and now you're working 25 hours a week, the government doesn't consider that material part-time work. You're still doing part-time work. I would recommend that when those hours start changing, rather than just letting them change, if you're going to see a significant increase in part-time hours, have some written record of it, right? Maybe there's a letter that you type, or the company, if you're the own founder of the company, it's kind of like you're typing, but I'm going to assume now the company's different from you. So maybe there's a letter that the company records in the what we call public access file that's related to the LCA that just says, hey, ABC's employment is now going to be on average 15 to 25 hours a week. And they just save it and store it there, right? But you got some record. Again, I'm thinking about these things from in the future, if I have to defend that this happened, can I do anything now to have a contemporaneous record so that it's good evidence, right? So do something like that. But you don't require filing. It doesn't cost you anything. But if you change from part-time to full-time, it's a material change. So you have to file a new LCA and then file a new H-1B petition. And then you can start working only after you do that petition.
I'm going to move to take some question from Substack, Raghavan, just because, people asked earlier. I'm going to give them preference before we move back. So I'm going to show them the stream as well. Halak is asking, I'm currently an F1 student who wants to open an LLC and receive payments for his AI automation business. I realized I can employ myself after establishing an employer-employee relationship, but curious how one would approach the situation. I'm a citizen of Turkey and my first year of MBA program. Thanks.
So if you are an F1 student, then you are, like everybody else in any other status in the US or outside the US, able to own a company, right? So you could form an LLC, own the LLC, and receive income from the LLC, right? None of those things are actually prohibited as an F1 student or an H-1B employee or whoever, the visitor even. What you cannot do, unless you have separate authorization, is perform work for the company, right? If you want to work for anybody, you have to have work authorization to do it. If you want to own something and that something generates passive income for you, then you own it. That's fine. You can buy a house and just collect money from it. And so if you're an F1 student, you're saying, I want to open an LLC and I want to get payments, I would say if you're truly not doing any work, then you can do it. There's no issue. But if you look at it like a lawyer, right? Like, hey, I'm getting money coming in from this company. So the government sees I'm getting money coming in from this company. They might ask, are you working for that company? Now, if they ask me that, I need to have pretty good proof I'm not, right? Because they might come in saying, I think you're working for the company. Prove to me you aren't working for them, right? And so if you're doing something where you maybe are doing some work, right? Oh, I was doing some development of the product, or oh, I was doing some customer integration, or I was actually doing app development, and you're getting money for it. And now the government sees you're getting money for it. And then they ask you these questions. They might say, no. Now that I'm digging deeper, I looked at all these things. I believe you're really working. So I think you've worked without authorization. You're violating your status, all these problems. So when you start taking an income, you're adding a risk, right? Because of course, now there's evidence of that income, and that income suggests you might be working. It doesn't mean you're working. You could be saying, no, I 100% own this business, but that guy manages it. That person actually does the day-to-day work. I just take the profits. Fine. You can do that as an F1. When you then want to be employed, unfortunately, when you're an F1 student still, there's very limited ways to get work authorization. You can do, and I guess I shouldn't spend too much time on this question because we're going to go back to the H-1B thing, but just to wrap up in a minute or two, you can do what's called curricular practical training. You can get an internship, basically, to do some work for a company. But then if you own that company and you're a manager at that company or an executive, it's really hard sometimes to navigate the CPT to show that you're really doing an internship. You can get what's called OPT, optional practical training. It's a bit more than an internship. It's when you're saying, hey, look, I required this experience in order to get better training within my field of my degree. Most people do that after they graduate, but you could do it before you graduate. You can get pre-completion OPT, and then you can do whatever you want for the company. And then after you graduate, post-completion OPT allows you to do whatever you want. But if you want to do further extension of that, which is called STEM extension, then yes, you need an employer-employee relationship. Nothing about these H-1B changes has changed the requirements for the STEM extension, OPT, kind of employer-employee relationship, right to control things. So I think if you're in that situation, you're back in the position that Sid was, back when he's doing his own H-1B, and we're saying, hey, let's make sure there's a structure at the company, that the company has an appropriate board of directors, you have an employment agreement, you have a clear separation of you and the company where the company controls your work, the things that we would have been talking about for the H-1B until the update in this rule.
Now, one thing that comes up in this, so a couple of things here. One, the spot where he gets the profits, right? So he's passive investing and he said, hey, I've got operators in the company. Can those operators be outside of US?
Yes.
Just a business law, nothing to do with immigration, right?
That's fine. Yeah, it's nothing to do with immigration. Yeah.
Right. It's a business
if they
thing.
are outside the US, then I guess you make sure you got a good way of proving it, that they exist, right?
Proper contractors
if the
being
government's
paid.
auditing or, somehow following up with you and they're like, hey, who runs this business? And you're like, oh, it's these people outside the US. They're not just like, oh, okay, fine, I believe you. They're going to say, okay, prove it to me, But it's legal for that to be happening. Just it might be harder to demonstrate.
Yeah, just like anybody will start a business in the US and have contractors outside. You could too,
sure.
Right? So I think I recommend, I recommend a lot of people too, if you can hire contractors, if you're not sure, want to get some work started, do it. You're from Turkey, get contracted in Turkey, right? Might as well get your AI automation kickstarted.
Minor last thought before we move on, because the person said they're from Turkey. Most of the people, I would say, and maybe I'm being inaccurate or unfair, and I don't want to do that, so I apologize, but most of the people likely in this community, and many of the people we talk to are people who were born in India or China. And that's because those two countries have more difficulty than people from other countries because there's not as many options, right? And there's a longer backlog. And so for most of the people in the call, this isn't going to be relevant, but if you're from Turkey, there's an e-visa. So you may actually want to go the e-visa route. If you're forming your own company, if you've invested time in it, if you're doing trade, you can get a visa to do that. Maybe if you want to spend some time, you can Google it. It's not really the subject matter of this conversation, but it's something I would look into if I was Turkish.
I'd suggest, Haluk, you reach out to Raghavan. I think you may have more options. The follow-up question on the same topic was regarding passive income. Means can one receive a said income is considered passive? Now, I have my own thesis on that. I know the word.
Yeah, you may be a better answerer of that question. That feels to me a bit more of a tax kind of question, or maybe defined more in the tax law than is in immigration, and immigration will probably borrow from that.
Exactly.
Yeah.
Exactly. I think that's a critical point, which I always want to tell people, that this idea of passive income comes from IRS. So if you are getting, so imagine I get income from a business, a house I bought, and it's on Airbnb, right? I get an income on my it's an LLC owned house, and the money flows through my tax return. I have to tell the IRS, is that money passive or active? Because they're taxed differently, right? So I'll qualify every income I make as active or passive. And, if you say that's active, then IRS will audit you and ask you, it's the same thing. So how you get the money, you qualify that as passive or active. I think that's the definition used. And I believe it's kind of vaguely used to define passive work as well, right? There's no clear definition of what passive work means, but
So when it comes to the income question, especially when it comes to tax things, I'm not an expert. So I don't want to express an opinion and then be wrong about it and be like, oh, I didn't really know. So I'll leave it to you, I guess, if you know those details about passive versus active income, or rules within the IRS, those kind of things. When you say passive work, though, I guess there's multiple different ways to think about that. If I'm thinking about it with an immigration hat on, which I guess is the only hat I own, then I don't know, passive work is like a optional antonym, right? Or a contradiction, right? Like if you're working, you're working. What does it mean to be passively working? No, I think you're either passive in your income source or you're working. And if you're doing work, then you need work authorization to do it.
I think I would, if for many of you are interested, you should look up IRS, how they define passive income. They have the language for it. You should read about it. Single for rental housing, it's where it's mostly used. Most people, buy a house and get it on Airbnb, and then they get the income from it. There are a lot of write-offs you could do with that income because your house is on a mortgage and you write off your W-2 income. So they avoid that by qualifying that income as passive investment. Right? It's actually avoid some of the tax breaks people get by rental property. Look up that language. So same thing with the LLC. If you can take profit distribution out of it, and if that distribution qualifies as passive, you're taking profit out of a company as an owner, and then you're not getting income that's active or not on W-2, which will be a violation unless you have a proper compliance. Okay, I'll go back to Substack just because we have more longer question and people have been nice to preemptively ask that. So this next one is, I'm seeking clarification on maintaining compliance with STEM OPT requirements while working full-time as the lead engineer at my own company in which I own 90% equity. Specifically, I have the following question. Will setting up a board of directors satisfy the supervisor requirement, given that the board will consist of only one director due to the small size of the company? Does the director need... So I think we'll go one by one.
Yeah, no. I could see the questions. I think that you should have a board that consists of at least 3 people. The reason I suggest that is this may be a more conservative approach than is required, but I'm a lawyer and we always want to be a bit more conservative about these things. So I think if you have a board with 3 people on it, including yourself, I mean, I'm assuming you're a member of the board. If you have a board with 3 people on it, then if the board can make decisions based on a majority of the members, that means the board could, in theory, outvote you on a decision about employment 2-1, right? And so you could say to the government, well, my employment is controlled by the board, and the board could fire me, right? They could, because there's 2 of them that one of me, if they vote, they could actually do that. They couldn't take away my ownership, but they could fire me from the job, right? And those are two separate questions, right? The example I think that Michael Sarasvati would always use is Steve Jobs got fired, right? So they can't take away your ownership, but they can fire you. And that's what's
Voting
important
rights.
when we're talking about the
Yeah.
employment relationship.
And
And so, sorry, go ahead.
I'm saying in my case, I don't know if you remember, but in my case, I created a board and I had me and my co-founder and I added my friend as well to make it 3.
Right.
And
And that's often the case when there is the kind of 2 co-founders. Usually you're saying, hey, we're both on the board. Great. Get a third person, right? So the language that we often are using is get a third board member. But I guess implicit in that language is because the first 2 are you and the co-founder. But yeah, I think 3 members of the board is good. Does a member of the board have to be an employee of the company? No, right? They have to be a member of the board. So you may have an advisor agreement or you may have a board member agreement, whatever legal requirement your company has to appoint a member to its board, follow that, right? And there are standards probably with, if it's a Delaware corporation, there are processes you use. You have some amendment or some board action or director appointment or whatever it might be.
I quickly add the bylaws amendment, and you don't have to file it anywhere. It's not like you add a board member and, oh my God, you fill this like big form and submit and get approval. It's a business, so you can consult a corporate lawyer if you want it, but there are templates available. You add a board member, you do a board meeting with meeting minutes to document it that we have added a board member, and your secretary and president of the company will sign it, which will be you and your co-founder in the beginning. So that's how you add a board member. And some people ask, do they have to have equity? I think Raghavan answered no. They will get a voting right without equity.
Yeah. And what's often the case, and a lot of times, I guess I should say, I frequently answer things because they're often the case. I don't always mean to say this is the only way you can do it, right? So I guess if people have questions when I say that and push back, please push back, because I may be just describing one way to do it. But very often when I interact with with startup founders, what's going on is they've got an idea, they've got a co-founder, and in order to get this idea going, they've got a mentor or somebody that's helping them. Maybe it's a professor from the university they went to, a colleague they worked with. It's kind of an advisor, right? So usually I'm saying, hey, get your advisor. Maybe there's an advisor agreement, but get them to be the third board member. And then great. Now, can you hold a majority stake in the company while being employed as a lead engineer? I think the answer is yes. I'm more skeptical and anxious about the dynamic with the STEM OPT. Of course, the answer today for the H-1B is definitely yes, right? The ownership doesn't matter. The answer for the H-1B before January 17th, I would have said, however much you own, make sure that much isn't enough to block your ability to be fired. If you own 90%, then make sure that there are 3 members of the board, and you could not, as the 90% shareholder, just unilaterally increase the board or block a board action or something. There may be bylaw changes that you need to ensure that. But understand, even if that's the case, still see officers not liking it. So we filed cases. In fact, there's a very similar example to the guy who owned 90%, where we did the STEM extension, we got the RFE. They asked about these details. We provided the information about how the role changed and what the ownership and all those things were, and it was perfectly fine and approved. And so I know these things are approvable, but I think that if you play that game, 10, 20, 30 times, there's going to be times you encounter officers that are going to say no to that question. So can you do it? Yes. I would say if you want to be maximally risk averse, if you want to de-risk, then keep your ownership. Proxy away the control of some of your equity, right? You're 90% owner, but let's say there's 100 shares in the company. I have 90 shares in the company, but 46 of those shares, I've proxied control of that to my co-founder. And so now I own 90%, but I control 44%, right? So I'm minority controller. Now the government can't say, hey, you control your own employment, because I don't control those shares. And that would be a good way to be bulletproof, and that's fine.
Interesting. And I want to re-stress, this is for OPT extension cases.
Yeah. None of this applies today to the H-1B because we don't have to show right to control. So we would
even before it was not a case. I mean, in my case, I had majority stake and we had the board. You're saying now it's even more clear. We have to not show the control
Yeah,
problem, so you could
exactly.
own 100%. And
Right. Now, I'm describing the rule in saying that. That is not exactly the same as providing advice, right? Because if you came to me and said, what's your advice? I'd say, we just turned into an administration. I don't know how they're going to interpret these things. If I were in your position and I wanted to be, again, risk averse, trying to de-risk this, I'd still do those steps, still get that board in place, still have that kind of ability to show it. You probably don't need it. The rules say you don't need it. But if you did it and then in 6 months, they're like, I don't know, we're not a fan of this, we're going to update things, you still put the things in place that you're still good, right? There may be some cost benefit to that, right? Because like, oh, it's going to mean you have to take these extra steps. I got to reach out to this person, do this. And so some people will look at that and quite legitimately, rightly say, okay, I hear you, but let's go forward just doing the things with the rules today. That's what I want to do, right? And that's your prerogative, right? And that's your decision to make as, I guess, the client, but if you were my client, that's your decision to make as the client. I want to empower you with the information to make it. But if you're asking for my advice, I'd say, be more cautious, even though the rules say this, because we don't know, since we're at this inflection between administrations, whether we'll see more shifting in the policy positions.
we are 8:59. Raghavan, can we take one more question? There's one more substat, which I think will be nice. So the one quick one actually before that, can the board member, do they have to have a green card or US citizenship? I think it's
No, they don't. They just have to be able to be a member of the board. I mean, they could be a foreign national, they could be outside the US. I guess if the board is supposed to meet periodically, they got to be able to do whatever the board is supposed to be able to do, right? Like different states have different kind of structural requirements for their companies, right? And so it's hard to have a one rule is true for all, but let's say, what if you're based on where you incorporated or what you did, it requires the board to meet every 3 months. And you're like, this person's on the board, they live in Libya and never come to the US, they can't meet. It's like, well, how are they on the board? So
that would be
as long as they can
true whether
legitimately be
you
on the board, they're fine.
Yeah, but that would be true even if you're not a citizen of US. It's a business
100%.
rule.
It's just
a
if you weren't
corporate
a
law.
citizen in the US, nobody would care. Sorry, if you were a US citizen, it probably wouldn't matter because it doesn't put at jeopardy this other question. But yes, that'd be true for any business.
So corporate law, if you can have an entity in US and have, two people in India can start a company in US and have this.
Yeah. And I think the question just before you just posted there was answered by you, right? Like, is there a document you need to file? Yes.
So bylaws for
There's a
C Corp
document,
and
not
different
necessarily
documents
need
for
to
LLC.
file, right? That there's rules based on the kind of type of organization it is. There's nothing in the document. Whether you need to file is a question for the corporate attorney, right?
I think you should Google that. These are like very easy to answer for changing a board member for C Corp. For your type of entity, it changes. So, all right. So I'm going to read for the group. If you want to just read through it, Rob. So I currently have full-time W2 construction industry and have H-1B through them. Below are my goals. Establish a real estate investment company with the initial focus on buying commercial real estate property. Syndicate model, start a consulting company related to BEAT, which was based on my EB1. But he has, I think I met at the tip. He has EB1A approved, which is still backlogged though. So he's still on his H-1B, and he was recommended to file a part-time H-1B so I can keep my job, current W-2, and he wants to start this real estate syndication entity in which he can get investment and buy properties and sell properties.
Yeah. So can I start one company and achieve both goals by the same company? Perhaps. I don't know whether you want to. I guess I don't know what the structure of the investment would look like, right? So maybe there's one company that is the investment company, and then it's got its own separate investment vehicles for each different real estate thing. This is an area of law and expertise that I don't have. So sure, frankly, full transparency, I don't know what using syndication model means. So perhaps that's something that people who are intelligent about this would know. But from an immigration perspective, I would say, if you want to keep the current job and do the part-time 5 hours a week, the first thing to know is, what are you doing in those 5 hours? I think it's indicated something like civil engineer consultant. So I presume that means that you're going to do the work of a civil engineer. You're going to provide civil engineering services in some way. Okay. Then you can identify your job category as civil engineer. You're going to have to get paid according to that job category. You can do the 5 hours a week, provide the consulting services. Yes, that's fine. I guess if you could say, I'm going to do this at this company. I'm going to do the civil engineering work. It's the majority of my time. And then the minority of my time is, because I'm the 100% owner of this business, is just doing the things required to make the business work. And some of those things are, signing the deals, negotiating the contracts that allow me to make these purchases. That's fine. That is things required to run the business. And it's explicit in the updated H-1B rule that if you're an owner, 100% owner or a greater than 50% owner, then as long as you're showing that at least 50% of your time is focused on the specialty occupation, i.e. civil engineering here, then it's okay if less than the majority of your time, say 48% of your time, is focused on activities that an owner would need to perform to have the business run. Signing contracts, negotiating deals, general operational things. And so
that's huge.
That answers the question.
That's huge.
Then I would say, yes, you can use one company and achieve both goals. But don't forget, even if you're using that minority of the time to do those other things, you're still using the minority of the time working. So need to be paid for that time you're spending working at the prevailing wage rate for the civil engineer, because that's the occupation that you use. So you might not be able to get it all done in 5 hours, but so maybe you're working a little bit more than 5 hours a week.
He has a follow-up, Raghavan, with like more concrete. We'll just take that last one. So he's a follow-up saying, if it's the same person, Aditya, if I fight for 5 hours a week and at $50 an hour, prevailing wage, that is $12,000 a year, and let's say after 6 months I get a contract for which company earns $100K. So as we show $12K, how can I get other remaining profits from the company? So you're saying I filed my minimum wage as lower, and now my company has more money. How do I get more money?
Why can't you get more money? Maybe I should be explicit. Like, what prevents you from having $88,000 of owner?
I think you're saying because my salary, or because I filed the LCA saying that my salary is $12,000.
Well, you would have filed the LCA saying my salary is 50 hours a week.
50 hours a week.
$50 an hour.
$50 an hour.
And yeah, you got compensated $50 an hour for the work that you did. Now, a prevailing wage is a minimum, right? So when you file that LCA, you're saying, I'm at least getting paid this. If you got paid more, it's not usually considered a material change. And so you could be paid more. But this, to me, is not salary. If I understand the scenario correctly, this person is going to be the 100% owner of this company. And the company just got $100,000.
Right, it's profit.
Right?
And
You have $100,000 in the bank. You have profit in your company. If your company is an LLC, then you now are going to be taxed on those profits. Probably, I'm not a tax expert. If it's a corp, then okay, maybe those profits somehow have to be filtered through to the shareholders through dividends. I don't know. But if you want to take that 88,000 out, I think you can.
You could, depending on the C corp
somehow, but you can.
Yeah, there's nothing stopping you, Aditya, from taking that money, because I think if you can be an owner on H1, now the rules have changed 100%. Right? It's your profit. How you get profit from your entity, there are books on it, right? Saving on taxes. But if you, let's say, just want the money, I don't care about saving taxes, I'll pay 30%. Mm-hmm. Just take it out as profit sharing. Any entity can do that. I do want to finish
because there's a second part to that, right? Like a more pessimistic part to that question, right? Like, so now I didn't make $100,000. I made nothing. How to show the salary being paid? You got a problem. The government would say, I don't care that your company did. If your company's not making money, then you shouldn't have that job, right? They can't employ you, right? So you are saying you're going to work 5 hours a week as a civil engineer and get paid a certain amount. In order to maintain status, you should be working and getting paid. If the company doesn't have money to pay you, what companies do is they fire you. They don't just let you keep working without paying you. That's not a way to keep going. So if you don't make any money on the business, then you do what every other business does. You close, right? And so you basically have the requirement when you're in H-1B status to get paid that amount. You got to get paid.
So I'll leave it to you, Raghavan. There are 2 more questions in the chat.
Yeah, sure. So let's see. I'm currently on F2. I've got an EB-1A. I plan to have a consulting company, which has 6 to 12 months salary in account without clearing contract. I mean, it's a difficult question because, number one, the person's on an F2, so I presume that they have previously had an H-1B, or they're going to go through the lottery and therefore obtain an H-1B, because we're asking about wage levels, which is really only associated with the LPA. Oh, this may be the same person saying yes. Great. So if you're now filing an H-1B petition, somebody else earlier on, I think this question was missed, asked this question about, hey, what wage level can I use if I'm CTO? Now we got what wage level can I use if I'm CEO? The first thing I would say to people is the title that you have here is something that I'm sure you're very emotionally attached to because you're a startup founder and you want to be CEO or CTO. But how important is it to you really? Because the day-to-day work that you do is what matters in analyzing what job category is appropriate to use. If you say, hey, I'm the CEO of this company, that's what I am. And if I come to you and say, hey, but do you do this, do you do that? And you say, fuck you, Raghavan, I'm CEO, right? Then I would say, fine. We got to use the job category of top executives. The only salary available in top executives in most places is wage level 4 because they get rid of the other ones. Pay yourself $300,000 a year, right? Or you could be reasonable and say, wow, look, the day-to-day work that I do is really software development work. So I'm kind of a principal software engineer. I'm the software engineer of the company. I might call myself CTO or CEO to investors or people, but I'm really doing that work. Great. Okay. You're a software engineer. Well, we can use the software engineer job code. The question of wage level is slightly different from the question of standard occupational classification, SOC, which is what, top executives versus software engineers or financial analysts or operations research analysts. Those are SOCs, standard occupational classifications. Within those SOCs, there's the 4 wage levels, right? But what SOC you use is really important because that's the first thing that's going to determine what the salary is. And the way you're supposed to select that is, what do you do? What are the day-to-day job duties? What job code does it most closely align with? And I would say, look at the things you're really doing and align yourself to the things you're really doing, rather than focusing on the CTO, CEO part. And second thing, in terms of level 1, 2, 3, 4, Department of Labor has what they consider a mathematical formula for this, right? They say an entry-level position is wage level 1. What entry-level means is the job requirements, the minimum requirements for the job are what is standard in the industry and no more, right? And so if it's standard in the industry to require a bachelor's degree for this job, then you require a bachelor's degree. You don't require a bachelor's degree plus 7 years of experience. You don't require a bachelor's degree plus they have to have these specific skills and these specific tools. You're just like, hey, requirement for the position is a bachelor's degree. Then you could be wage level 1 if the standard is bachelor's degree for the industry. Some industries aren't. A lawyer, the standard is, hey, you got to have at least a law degree, right? So it's not enough to have a bachelor's degree. And so that's wage level 1, entry level position, 0 years of experience, maybe 0 to 2 if you get technical, because they have these different wage levels. They have these different levels that I don't remember the name for now, but they have these levels of these experience things. So 0 to 2 years of experience. Wage level 2, or maybe not wage level 2, the way I should describe this is you have to bump up a wage level. You have to increase by 1 wage level if any one of the following are true. Company requires more than the minimum education requirements. So, hey, it's standard to require a bachelor's degree for a software engineer, but we require a master's. Okay, now it's up to wage level 2 because you require more than normal. So it's one way you bump it up. Another way is if you require more experience, right, than is entry level. So, we don't require 0 to 2, we require 3 years of experience. If you require several years more experience, then you have even more increases in that wage levels. Another way is there's managerial responsibilities when the industry doesn't normally require it. That bumps up a wage. And the last reason is there's some special skills required that isn't standard, right? So these kind of 4 ways you bump up, right? Higher standard education, more experience, being a manager, having special skills. So when you say, can I select wage level 1? I say to you, what are your requirements for the position? And the biggest mistake people make all the time and hardest thing to try and get through to clients is your qualifications are not the same as positions' minimum qualifications. Don't say to me, we require a master's degree and 14 years of experience because that's what you have. Because if you really mean that, then we'll wage level 4, right? But would you accept for the position a bachelor's and a couple years experience? Sure. I have more than that, but I'd accept this. And so, yeah, that's how you determine those things. I don't think I directly answered the question, but that's the information. Cool.
Well, we're out of time. It's 9. So thanks for staying longer, Raghavan. I think we can do it again next month or 2 months from now. As you know, this is pretty interesting times. I think people are going to have a lot more
I don't know
questions.
what will change in that time. Like I said earlier, I doubt that the actual rules will change in that time, right? It takes longer to change the regulations. But policies may change. We may get executive orders that impact day-to-day operations here. So it may be interesting to see in a month and 2 months, what does this administration do here?
Yeah.
If I had a gut feeling, it would be this administration, if they're like the first Trump administration, is going to be more business friendly, or at least want to be more business friendly. So I doubt they would make it more difficult for H-1B founders. But again,
All right. Thank you, everybody. Until next time. Bye-bye.